Hi, I'm Jen Rubin, editor-in-chief of The Contrarian. Back with us is our very own Andrew Weissmann to talk to us about the Supreme Court ruling that finally came out today. It was a 5-4 ruling in favor of the challengers to Trump's attempt to, and Musk's attempt to freeze development money going for foreign aid. Andrew, welcome. What did the Supreme Court decide, and why did they decide the way they did?
Well, the narrow reading of it is 5-4. They decided not to stay the district court decision. So obviously that means they agreed with the district court that it could go forward. They also thus agreed with the Court of Appeals that also had said that they would not enter a stay and it could go forward. And the Supreme Court 5-4 also said that they would get rid of their temporary administrative stay that the Chief Justice had put in place last Friday, and that the case could go forward in front of the district judge without a stay on her decision.
Court judge explained that she granted the order, meaning that the government had to release these funds. What was her rationale that although the Supreme Court didn't reach the merits, that they, in essence, allowed to carry the day because they lifted any kind of barrier to that?
Sure. So this is the case where the plaintiffs are people who are the beneficiaries of money that had been appropriated by Congress. That's a key part. Congress had decided to fund USAID, and the USAID had spent the money in various ways, and or had contracts to spend the money. And we've talked about, and there's lots of press about just how important this is, not just as a sort of moral component of saving lives overseas, but how much it helps us in terms of our safety, in terms of disease and national security. I'm not going to belabor that. That's really not almost relevant to that's relevant to the policy issue, but not really relevant to the legal issue. But this was money that was going to all sorts of very good causes. And the administration had said, we're stopping all of it. Put your pens down, stop everything. And the plaintiffs said this violates all sorts of rules, procedural rules, as well as the executive branch is interfering with congressional authority. There are two branches of government. So those were the claims. And in a very lengthy decision, the district court had said that it agreed with this. And the thing that's important here is, and that's sort of getting in the weeds, but procedurally, the judge had issued quite some time ago, about 2 weeks ago, a temporary restraining order. And then, according to the plaintiffs, the government had not complied. And so they go back. And the judge said, I meant what I said. And you say you're going to do it, so you need to do it. And that sort of goes on and on and on. And ultimately, the judge just says, I've issued a lot of orders. And now, with respect to the money that for contracts that have been performed, in other words, money that you got something for, the contract is over. Like they did something, you agreed to pay for it, and thus for that subset, you need to pay it, and you need to pay it now, and gave them
Yes.
a deadline. And so this was in many ways then, and the what again, to be in the weeds, a temporary restraining order cannot directly be appealed. That you have to wait for this, what's called a preliminary injunction. It's just a procedural rule in federal court. And so here there had been a temporary restraining order, but they couldn't appeal that. What the government was appealing was frankly a motion that was and an order from the court saying you need to comply. You're sort of essentially in contempt of my temporary restraining order. I mean, so this wasn't even this was weaker than appealing a temporary restraining order. This is this is appealing, not complying with the temporary restraining order.
Right.
So that was sort of the procedural posture that
Well,
led the Court of Appeals to say, no go, you got to comply.
what's interesting about the Supreme Court ruling, that deadline, by the way, passed a long time ago because, as you said, they took it up to the circuit court, they took it up to the Supreme Court, there was a stay. It took them a while, and we'll talk about why we think it took so long for them to finally get the opinion out. So the court was pretty lenient, actually, and it said you have to comply as soon as that's possible, and the court should make very clear what the subset of payments really are. So in that sense, they were almost, I don't want to say lackadaisical, but they were generous in their treatment of the government, which had refused to comply with this over and over again. So there was a very long dissent drafted by Justice Alito with three other justices signing on. By the way, people should note that Chief Justice Roberts and Justice Amy Coney Barrett were in the majority. That is, they were siding against the government. And that's an alignment that many of us have pointed out is not usual, but more common than not, that on the more extreme positions that the very right-wing justices take, sometimes Coney Barrett and the chief will go the other way.
Jen, can I just point out that
yes.
that is the same alignment that we saw in allowing Judge Merchan to go forward with the sentencing
Yes.
in the Manhattan criminal case, where those are really the two justices to keep your eye on as we go forward in the next 4 years. So
yes.
I interrupted.
And that's quite right. And those swing justices, by the way, are so far to the right. The concept of a swing justice is now very tortured, if you will, because the whole court has moved so far to the right. Be that as it may, Justice Alito wrote on for 8 pages, much, much longer than the majority opinion, and he was hot and bothered. What is he so upset about? And does he have justification for being so upset?
Sure. Can I just make one point, though, about the majority, which is there isn't really a sort of a lot of reasoning, but when they sent back to the district judge, there is some language that I think is pretty hopeful in terms of their general approval of what she's doing, because they basically said, as you go forward with respect to the preliminary injunction, essentially, please pay attention to legitimate time concerns the government might have. I agree with you, Jen, that they could have been much harsher with the government, but that's pretty good language if you were the plaintiffs. If that's all that they're sort of saying to her, that's pretty good, especially when we now turn to Justice Alito. So I wanted to read to you the opening sentence from Justice Alito, because it kind of tells you the key part. And it's worth, as you said, noting it's not just Justice Alito. It's remarkable because he has 3 other justices joining him. Here's the question that he starts with. Does a single district court judge who likely lacks jurisdiction have the unchecked power to compel the government of the United States to pay out, and probably lose forever, $2 billion taxpayer dollars? The answer to that question should be an emphatic no, but a majority of this court apparently thinks otherwise. I am stunned. Well, Jen, I am stunned, because you know what's missing from that paragraph?
Truth, the accurate explanation that Congress passed this legislation.
Exactly. It's Congress. This is like, oh, I'm sorry. It's like they're making it sound, if you read that and you think this is going to be now quoted on Fox News and other sort of far right, I can't say news programs, outlets. Perfect. Exactly. The thing that you're missing there is, oh, wait, I'm sorry, there's another branch of government.
Right.
It's not like the judge just said, I want to spend this money for X, and so I'm ordering you to spend it for my child's tuition. I mean, it is unbelievable that the entire gravamen of the case is that it was congressionally approved. And so that's sort of step one. Then I don't know how to explain to you, he has some sovereign immunity argument that I am not smart enough to understand it. Let's just put it that way. I was quickly read it just before class today, and I reread it before going on. I don't know what to tell you. I'm sure somebody much smarter than I am will be able to explain why this makes sense. I don't understand how sovereign immunity has anything to do this when you're talking about a case where someone comes in and says the executive is usurping congressional power. How does sovereign immunity is usually when a private party is suing the government on their own, and they say the sovereign can't be sued for that. This
Right.
is this their gravamen has to do with the um, the um, the interplay of the two branches. So
Yes.
I just don't get it.
And to be very specific, if Alito were right, then no one could ever enforce a government contract because the government, this is a promise to pay for services rendered. So if you can't sue for this, what, every payment is just voluntary to the government from the government? It makes no sense.
Yeah,
Who would do business
tell
with the
it, tell it,
government?
tell it to Northrop Grumman and General Dynamics, and
Right?
this is like, could you imagine the government's like, listen, we're going to enter into a bunch of contracts, but you should know it's a one-way street.
Yes, we may not pay you at the end, and you can't sue us. By the way, I don't understand why he thinks the district court doesn't have jurisdiction. Jurisdiction means you have no right to hear the case. Where would he suppose they go? Or does he think no court should be able to hear this case?
I think if you thought that this was going to be encompassed by the exclusive and preclusive power of the executive, that it's a form of saying that this is beyond the reach of the courts because it's like the presidential immunity decision that said that the president can have communications with his attorney general, and you can't be criminally charged for that. It's exclusive and preclusive. Then it's that I think that would be the argument, but it's just stunning. I mean, just to be clear, that is for big picture for people listening to this, is the scope of that part of the presidential immunity decision last year is going to be the battleground. And that's where I just want to give a shout out to Amy Coney Barrett's concurrence because I really do think that she will be joining the other three women. I think you will have four. I mean, it's notable how gendered this is. You will have the four women saying that exclusive and preclusive component is small within the constitutional framework.
Concurrence, you mean her concurrence in the immunity
Oh,
case, not
yeah,
in the current case.
yeah,
This was
exactly.
her decision that, okay, I'll go along with immunity, but you really didn't have to decide all this other stuff. And you don't really need to talk about all this other baggage, including what evidence gets in. You could have just decided a much more narrow case.
Absolutely. And so I really think, she is going to be key. And so I think obviously she's a swing vote, but I think it's really going to come down to Roberts over and over again as to where he is. And so, that this is a sign of that. As we've talked about, this is now the second time that we've seen this particular alignment, but I'm still very surprised that Alito managed to get three
Yes.
justices to sign on to this, of which, the one I'm most surprised by, I shouldn't say surprised is probably the wrong word. I thought Kavanaugh was more aligned with Chief Justice Roberts, and he seems to very much have thrown his lot in
Right.
with justices where I find it very hard to understand their reasoning.
Yeah. I think the difference is that Alito has always had this very extreme view of executive power, at least when Trump is in power. When other presidents have been in power, it hasn't been that extreme.
Right.
Although Kavanaugh is a big proponent of executive power, before the last couple of years, it never seemed that he took the position that essentially the president is king, that the courts can't review his action, that the president gets to decide whatever he wants to do. It wasn't apparent to us, I think, until the last session or so, that he takes this very extreme view of presidential power. And I think that's what, if not surprising, we thought he was better than this, put it that way. And once again, you can never underestimate really how extreme these people are. And I think that's kind of revealing again in this.
So what I would say to the nerds who are following this and want more, and what I would say to any of the Supreme Court justices if they were listening to this, is I would really ask them to read carefully Justice Jackson's decision, not Ketanji Brown Jackson, but Robert Jackson in the Youngstown Steel case. Justice Jackson wrote a very, very famous concurrence. It's known for this tripartite test, but the main thing that's notable about it is that he puts executive power in historical perspective. And the reason it is so powerful to read now is that he was the chief prosecutor in the Nuremberg trials. And he is giving a warning loud and clear for what happens to countries when you have an executive who is unchecked and how important the courts are in that. It is such a good antidote to what our court has said in the presidential immunity decision. So I highly, highly commend it. It's beautifully written and it's heartfelt. And when you know the history of who he is, it takes on that extra measure. And I think for what we are going through now, without analogizing to Nuremberg, it reads loud and clear as a very important lesson that people need to take to heart.
Well, I think whatever you thought of that State of the Union and whatever you thought about that weird interplay between Trump and the Chief Justice, where he seemed to be maybe thanking him for the immunity case, was not clear. What this says is maybe we do have a Supreme Court after all. Maybe the Supreme Court isn't entirely corrupted by politics. So let's hope that interpretation is right and that Amy Coney Barrett and the chief stay on the side of constitutional law and limits on the executive. But thank you once again, Andrew, for making everything crystal clear, even though a lot of what Alita writes is not crystal clear.
I know. I really don't feel like I added to it, but I tried.
I know, some things are just beyond the human ability to explain. So thanks so much. We'll see you next time.